Thanks for joining us. Now, the issue of the second docket took center stage in the Meyiwa murder trial today. The docket is said to be calling for all those who were present inside their house during the murder to be charged. Defense for accused number 5, that's Advocate Zandile Mshololo, says this shows that her client now is being prejudiced. The trial has been postponed to resume on Monday. For more on this, get some analysis from legal expert Nthabiseng Dubazana. Nthabiseng, good afternoon. Thank you very much for your time this hour, Ms. Dubazana. I know I've just spoken to Kelly Khumalo's lawyer, and a short while ago also to my colleague Lindelo Masigane. It's not the first time we're hearing in this case about a second docket, but it's the first time from my recollection that it's presented sort of in court and is discussed, and then the defense for accused number 5 says, no, stop this, we're feeling prejudice about this, let's go away and study this docket. What's your take on what has happened today?
Well, it is one unprecedented that it happens like that. An entire docket is only going to be presented in the middle of the trial and in the middle of cross-examination for that matter. So what usually happens is that before the trial commences, we are given access to the entire docket so we can go and consult with our clients in preparation for the trial and, and cross-examination that will come, etc., etc. But now that we are dealing with a situation of a docket that was first mentioned by a defense attorney being advocated for during the trial, and then all of a sudden it's now being presented. How is it being presented? Is it being presented as evidence to support this current matter? And if so, in what manner? How are you joining this matter to the one that is currently before court? Because in that matter, there is other accused persons which do not include the accused persons before the court right now. This is what Advocate Mshololo is trying to get the DPP to clarify for her so she can understand how those accused persons are going to be involved in this matter, because that docket makes no mention of her client as an accused person.
Yeah, similarly with Ms. Magdalene Munsami now telling me that her client, that's Kelly Khumalo, and who's mentioned in the supposedly in docket 375, the second docket, as one of the people who should have been charged, according to the jurisdiction of the South Gauteng High Court. They were not aware of it. She's writing as we speak to the state prosecutor asking for access to that docket. What is this likely to lead to, Ms. Dubazana? Because this trial has been delayed for so many years. I mean, Meyiwa was shot and killed in 2014. It's taken us to get this far, but like a month into the case, as you say, unprecedented way, a docket is now discussed and presented, and names of people who are allegedly to have been charged is mentioned. Now there's another postponement. What's the likely impact of this?
The likely impact that I foresee should this, once the DPP makes their decision, and it'd be very interesting to see how the DPP goes in this one. But let's say for argument's sake that the decision is that the docket 374 is being joined to this one, and being joined in the sense that the accused persons in docket 374 are being added to the
375, sorry,
here.
375, 375,
I beg your pardon.
Yep.
Then it being added to the accused persons here, it may lead to this trial setting de novo, because it means all the evidence that was put before the court for the one witness that has testified, which is Ntatemusia, then that evidence has to start from scratch. So these new accused persons can then hear what is being said and then prepare themselves for cross-examination as well. So we're looking at the possibility of this trial starting de novo, or that's the only thing actually I foresee it happening. Yeah. I don't know how the DPP will deal with it.
So we could see a further delay. Let's say the DPP, that's the public prosecution, the state prosecution, decides to join this. I'm just using my layman words here, Ms. Dubazana, to join the docket that is currently on in trial, the 636 docket, to the 375 docket. This is the second docket. That means we have to start from scratch, everything.
Basically, that's what de novo means, because what would happen in the normal course of things, it is not unusual to have two dockets stemming from the same crime. But what happens is that when the dockets finally go to court and the state realizes that, okay, there's two complainants for the same crime or whatever the case may be, they join the older docket to the newer docket, and then it becomes one docket. So all the statements and everything from the old docket form the new docket, and then we proceed. So nothing nothing really changes. It just means that there's more witnesses or there's more accused persons. But this is before the trial actually commences. So by the time the trial actually starts, the defense will then be given with everything that stemmed from the old docket to the new docket, which is now in one docket, and then we continue. So this is very unusual that it would happen in the middle of a trial. It will be very interesting to see how the state will explain docket 375 and why it was never put on the roll in the first place. Was there a nolle prosequi certificate issued in that docket? If so, why is it being presented to the court today? Or will there be a joinder? It's going to be very interesting how it works out.
And then the question of jurisdiction will come into play, won't it? Where are you going to try this now? Because we understand 375 is a docket from the South Gauteng High Court, and the current one, 636, is in the North Gauteng High Court.
Correct. So then it will but then these courts share concurrent jurisdiction. So that might not be so much of a bigger issue. They might concede that the matter can continue within the Pretoria High Court. But I know that I would argue that as the attorney for this 375 docket and say that no, the court that has jurisdiction here would be the South Gauteng. So what will then happen? The court, the prosecution will have to decide which one is going to take precedent. In fact, I don't know how they're going to do it. I don't want to lie, because they can't let this one go because it's proceeding. And then this one also exists. You can't have two trials on the same matter in different courts.
Yeah, because we're coming from a world where there were clearly two investigations that led to the creation of two dockets in different parts of Gauteng for this case. Finally, Ms. Dubazana, so Judge Maumane today had no choice but really to listen to Advocate Mshololo and take her appeals into consideration that her client, accused number 5, is being prejudiced by the introduction of this docket 375 and therefore postponed until Monday.
Definitely. When you look at Section 35 of the Constitution, which is the rights of accused persons, it covers all these things that Advocate Mshololo was arguing before the court. The prejudice that they're suffering, because remember, we don't have any other time to prepare our clients for trial up until we have the information from the state. So now if I'm going to be bamboozled out of nowhere with this new evidence, my client is not prepared for this, and neither am I. So the court has no choice but to grant that in the interest of justice and also for the interest of the accused persons, to grant them the opportunity to consult with their legal practitioner and prepare a way going forward in the matter.
Come Monday, it's going to be very interesting to see what happens going forward. Thank you very much for your time. That's legal expert, the Ntabiseng Dubazana.